and Licensing Bill, which you have deferred at the moment pending its stage 2, all of that would come under any other enactment. So if there's a contravention of, let's say, the serious organised crime provisions in the Criminal Justice and Licensing Bill, if that is enacted, that would be a reportable issue. Now, once the approved regulator gets the report, what does it do with it? Well, I don't know what a future approved regulator will do with it, but I can tell you what we do with these reports at the moment, should we get such a report. We have meetings with people like the Scottish Crime Drug Enforcement Agency and the Scottish Business Crime Centre. That's the kind of thing that one would expect an approved regulator to develop as a relationship with those law enforcement agencies to make sure that your money laundering tanning salon doesn't rebadge as as a licensed provider of legal services.
So just to be clear, could association with, criminal.
Let's say if Mrs. Corleone wanted to buy a law firm, what would happen if Mrs. Corleone wanted to buy a law firm? Well, I suppose the approved regulator would turn to Schedule 8 in the bill and say, I can ask Mrs. Corleone for her name and address. And it's an offence for Mrs. Corleone not to give her name and address, but it's also an offence for Mrs. Corleone not to answer any other reasonable question, like, are you married to Don Corleone, the famous mafia boss? Do you really want to own this law firm? And I think that that would put an approved regulator on notice that there's something up if it were discovered that there was an association. Now, also in the Criminal Justice and Licensing Bill, if I'm right, there are provisions about association. And I know that this it vexes the committee just a bit, but I'm sure that by dint of cooperation, we'll be able to pin down the precise terms of what an association is and how that impacts on your capacity to own.
And would these all be able to regulate anybody who just wanted to invest money within a firm as opposed to own it?
Yes, yeah, it's about outside investors is the term which is used in the bill.
Okay, now deal briefly with the multidisciplinary practices and difficulties that might arise. Angela Constance.
Thanks, Convener. I will be brief. Mr Smart, in many of the answers to questions earlier this morning, you've begun to touch upon the issues to do with multidisciplinary practices, and you've said implicitly a few times that some of the ethical issues have already been worked through. I just wonder if, in very general terms, whether you can say that with the regards to the regulation of multidisciplinary practices, whether you're satisfied that the bill provides a decent framework for dealing with different professionals with different codes of conduct.
We think the bill does because the bill is permissive. We think more work would need to be done at the regulatory stage, and we for ages and ages we kind of worked about for a really simple example. People would understand that, an ethical conflict, and the one that we came up with was in relation to lobbyists. As you may be aware, a lobbyist, registered lobbyist, must declare all of their clients so that on the face of it they cannot be acting nominally for one person, whereas actually in reality they're acting in the interests of another. Our rules, on the other hand, make it quite specifically a breach of professional rule to disclose the identity of your clients without their permission, because that's part of the veil of confidentiality of consulting a solicitor. And we came to the conclusion that in that area, for example, simply the conflict of ethical codes would mean that that's not something we could ever. We can't square these two things, and that could never be an MDP, although actually in other respects the interests of these two types of people fit quite neatly together. You can see the advantage of the lobbyist giving advice on the changes you want to make to the bill and the lawyer drafting the actual amendments that you would be suggesting. But we cannot see that these two things could be contained within the one practice. So there will undoubtedly be associations that we wouldn't be prepared to allow. I mean, there may also simply be associations that, for the sake of the preservation of the dignity of the legal profession, we wouldn't imagine that a multidisciplinary practice involving, a solicitor and a rag and bone man that, could clear houses for executaries or something like that for you, would be an appropriate multidisciplinary practice.
The other example of a conflict you gave was between surveyors and solicitors, and I think, if I'm correct, you described that as somewhat fanciful and a very obvious conflict of interest, so it just couldn't happen. Given your earlier answer, are you saying that where different professional codes of conduct, where there's an obvious clash, actually that's going to be headed off at the beginning because they just won't be able to do business together in the first place? Therefore, the issue about regulating conflict and professional standards in some respects is redundant?
To be fair, I'd answered that question in the context of the bizarre proposition that was put to you by the OFT that the surveyor could act for the seller and the solicitor could act for the purchaser. I mean, I can't imagine that the surveyor's code of conduct would allow that, never mind the solicitor's code of conduct. There's just such an obvious conflict of interest. We do think, as I say, I think I did give you an example earlier on of somebody who maybe got into the business of land development, where there might be legitimately a surveyor and a solicitor in partnership in a business enterprise, but they would patently have the one client, and they would only be acting for that one client. They wouldn't be acting for the people that were selling the land as well as the people that were acquiring the land. That, as I say, for us, that's out of the question. You would need to ask them. I suspect the surveyors would say it's out of the question for them as well. So.
You're quite confident that any conflicts of interest can be adequately dealt with?
Yeah, we have to deal with these things as we go along. But in terms of the sort of people at the moment, at least, that seem to be in the market, I agree with what Nigel Dawn said about regulators. But the other obvious group of people with whom a lot of solicitors association are independent financial advisors. It's a very common business model now that within solicitors' firms there will be people who give investment advice, who are professionals, are regulated by the FSA, but can't be partners or part owners in the business for which they work. And we think that their regulated code is very similar to ours anyway, but we think that the regulatory conflicts there can be worked through.
Thank you for giving that. Just, I don't want to get into a long list of possible, business models and various people who would or would not be involved in it, but just when you were talking there about a couple of the examples that might seem inappropriate, I just wondered what your opinion would be of an association between a solicitor and a medical professional. In terms of medical negligence cases, I just wondered whether there's a conflict of interest there, or indeed private investigators, whether or not there's a conflict of interest there, or do you think that could be worked out, or should it not be worked out? Should it...
To be honest, you've answered kind of two different questions there. I cannot myself see the difficulty with I mean, I do a fair amount of medical negligence work, and one of the absolutely critical things is that your expert is independent, that your case would fail if your medical expert had a financial interest in the success of the case. I mean, ironically enough, if you go back to McTeer, that was one of the reasons that litigation failed, at least in the opinion of the judge, failed, because the medical experts were acting pro bono and therefore had an interest in having it found that smoking caused cancer. Now, that's just an example. If that kind of business model, I can't really see how that would work. I suppose in certain circumstances, maybe to do with adults with income, I mean, I'm thinking off the top of my head, adults with incapacity or whatever, there might be some kind of scope for some kind of joint business model, but I'm flying that. The issue of a private investigator, I mean, that's interesting because I did talk about the concept of employee share ownership. Some of the bigger firms will actually have employees who are charged with taking statements and doing investigatory work, and they might well be in a position to participate in an employee share ownership arrangement. That there are issues for us. One of the issues that we would have to certainly be very careful about people being in kind of more formal partnership with private investigators is the touting rules about not improperly attracting business by getting around the solicitor's code on that, by implying somebody who's not a solicitor who goes out and says, why don't you transfer your business to Ian Smart, he's a great lawyer, so I mean, these would clearly be regulatory areas for us. But again, that touting provision, I would think, would be in any regulatory regime that we put in place for a multidisciplinary practice.
It wasn't just the touting I was thinking of. It was also the issue of it would be in the interest of the private investigator to, if you like, come up with the evidence that would be helpful.
I mean, all of that gets tested in court. And under the current system, there's not dishonesty